Okay, so welcome back to Chapter 7, Consideration and Form, Part 5. In Ward v. Byham, 1956, Lord Denning states that, "I have always thought that a promise to perform an existing duty should be regarded as good consideration, because it benefits the person to whom it is given. The father receives the benefit that was stipulated, which was the mother to prove that the child was well looked after and happy. The father's promise should be honored. Consideration can be anything beyond a basic legal duty." Section B. Duty owed to a third party. Consideration is not a promise to perform a duty owed to a third party. The promisee may be subject to a pre-existing contractual duty owed to a third party. The performance of a duty to a third party has traditionally been viewed as good consideration. This is particularly true in the family situation. If the promisee obtains the benefit of a direct obligation, there will be a valid consideration. Alright, so in Scottson versus Pegg, Scottson contracted Pegg to deliver coals to a third party, or to the order of that third party. That third party sold the coals to Pegg and ordered Scottson to deliver the coal to Pegg. Pegg promised Scottson that he would deliver it at a fixed price. Scottson took action to enforce Pegg's promise, but Pegg argued that the promise was not binding due to a lack of consideration. Pegg argued that it lacked consideration because Scottson performed a pre-existing duty to a third party. Scottson did not provide valid consideration that would bind his contract with the third party to deliver the coal. The court held judgment for Scottson. Scotson's delivery of the coal was a benefit to Pegg. Thus, there was a valid consideration. The performance of an existing contractual duty to a third party will constitute good consideration. There was a legal detriment to Scottson. In Shedwell v. Shedwell, 1860, it was held that if a pre-existing duty was performed for a third party, there would be a valid consideration. The uncle promised to pay his nephew £100 once the nephew married his fiancée. The estate states that there was no consideration for the promise to pay £150. Pow-on is also an important case with respect to the pre-existing duty rule. This case was unsuccessful in using the pre-existing duty rule. It was ruled that a pre-existing duty to a third party is enforceable if the agreement was made without duress. If the new promise was foreseen at the time of the main contract, there is no issue of the new promise being considered a consideration past. However, if the new contract was to replace the original contract and the original contract recognizes the past consideration, the new contract will be and should be enforceable. Right? Section C, duty owed to a promisor. Section C, duty owed to a promisor. Duty owed to a promisor or a pre-existing duty is not consideration to do something you are already obliged to do. There are a few cases that will lay down the groundworks for this doctrine. A consideration is not a promise to perform a contractual duty already owed to the other contracting party. Promisee may be subject to a pre-existing duty to perform the act in a pre-existing contract with the very promisor. There must have consideration for modifying the existing contract, but modification is enforceable when there is a rescission and a new contract, seal or accord and satisfaction, estoppel. In the case Harrison versus Watson, the captain of the ship promised Seaman Harris to pay additional wages because the ship was in mortal danger. In return, Harris would perform some additional work. At the end, the cargo was lost. The main issue here was an implied condition. Was there an implied condition? The main issue was whether there was an implied condition can exist as a claim for an exception to a valid contract based on a dangerous situation. In this case, the court ruled that if the ship lost the freight, all wages are lost. The cargo of the ship is lost. Thus, as a result, the sailor will also lose its wages. The principle of public policy was that argument struck in circumstances where the crew might have taken advantage of the vulnerability of the captains ought not to be enforced. Page 245. This rule will prevent the sailor from scuttling the ship to collect their wages without working for it, or the sailors could extort their money from the captain in exchange. It prevents the sailor from taking advantage of the captain's vulnerability. This case was dismissed on Lord Kenyon's decision. On a principle of policy, they would, in many cases, suffer a ship to sink unless the captain would pay an extravagant depends on might proper to make. Page 245. Okay. The decision from Harris versus Watson was later applied in the decision Still versus Myrick. In this case, a sailor was returning home to London from the Baltic. Each sailor was to be paid £500 or £5 per month. Two sailors had deserted the captain, and the captain offered to split the remaining wages among the crew members. The issue here was whether the plaintiff was entitled to additional payment for taking on additional labor when an emergency on the ship occurred. The court ruled that the agreement lacks consideration. Okay, because there was a pre-existing duty. There was no consideration for the pay to promised to the other sailors who remained on the ship. The crew had a pre-existing duty to do all they could under the emergencies of the voyage, and were bound by the terms of the original contract to exert themselves to the utmost to bring the ship in safety to her home destined port. Page 245. Alright, this is a void for a want of consideration. The sailor had given nothing more to the captain as consideration. The promisee must give some consideration. The transfer burden was something the sailor was required to do. One-side variations of existing contract will fail due to the rules set out in the pre-existing doctrine. However, in another case, the promise to provide additional consideration is extracted by a promisee who was exploiting the promiser's vulnerability. Page 245. Alright, so in the case Smith versus Dawson, Smith was contracted to build a house at a fixed price. Just before completing the house, a fire broke loose and destroyed much of the house. Smith had found out that Dawson had an insurance on the house and refused to complete the house unless the insurance money was given to Smith. Dawson wanted to keep the money for the furnitures lost in the fire. In this case, the insurance money given to Smith was not binding for want of consideration. The court ruled that giving up your right to a breach a contract is never a good consideration. Promise to perform an existing contract is not good consideration. Alright, so that is the end of part 5, chapter 7, consideration and form. Next time we'll be back, we'll be looking at Gilbert Steel versus University Construction. Alright, pre-existing contractual obligations. Okay, so until next time, take care.